Good afternoon. I have 12:30. Believe Jerry is with us. My name is Brian Ellis. I am counsel at Bressler, Amory and Ross. My colleague Jerry Levine, general counsel and secretary of IPSoft. Thank you very much for joining us, for taking the time out of your afternoon for what I think should be a fairly lively discussion about email and communicating in a virtual world, taking a look at some of the ethical considerations and then some of the best practices and sort of rules of etiquette for how to communicate and best get your message across and the intended message that you'd like to get across. So first, I'd like to thank Jerry Ford of Howard University Law School. He was a recent summer associate at our firm, for his excellent work in researching and assembling the materials for today's webinar. I also want to thank Rebecca Johnson for all her work and efforts in helping to prepare the materials. So again, like I said, my name is Brian Ellis. I'm counsel in Bressler's financial institutions, litigation, cannabis, and cybersecurity practice groups. I'm also the chair of the Morris County Bar Association Financial Services Committee and a inaugural member of the Penn State Schreier Honors College Diversity, Equity, and Inclusion Committee at Penn State. Jerry, would you like to introduce yourself and your company?
Sure. Did I turn my speakers on? Did I turn my mic on?
Yes, sounds good.
Excellent. I can use technology, being the GC of a tech company. Sure. My name is Jerry Levine. I am the general counsel and corporate secretary of IPSoft, which is a global AI and automation company. We have been around for about 20 years, spanning from New York to Tokyo, India, Australia, all over the world. It is highly likely that if you have interacted with a very intelligent customer service robot, it may have been us, which we're very proud of. I've been with IPSoft for about 5 years. Prior to this, I was acting deputy and assistant general counsel at Barnes & Noble College as it spun off from Barnes & Noble. I've worked with, it's not as popular to say I've worked with them in North Jersey, but I worked for a unnamed professional New England sports team, not as a player, but as a lawyer. And before that, I have practiced in New York, New Jersey, Pennsylvania for about 15 years now.
All right, very good. Well, look, Jerry, thank you for taking the time today. I was looking forward to this for a while, and I appreciate you taking an hour to talk about email and ethics with me.
Absolutely.
Great stuff. I wanted to mention to the folks in attendance, there is a chat function. If you have questions or comments, please feel free. We'll save some time at the end to go through some questions and talk about some of the comments. So, as I mentioned, we're trying to break this into two pieces, and the first is the nuts and bolts behind communicating, and this is really focused, but this is for attorneys who find themselves communicating with clients, with adversaries, with courts, just general business correspondence. So I wanted to try to talk about some higher level considerations, but certainly kind of show the evolution of how this field has kind of grown. So in 1999, the ABA put out a formal opinion that essentially established there was a reasonable expectation of privacy in email, and that a lawyer may transmit information relating to the representation of a client by unencrypted email sent over the internet without violating the model rules of professional conduct. And try to think back to 1999. I mean, Jerry, certainly a different time than 2020.
I don't remember anything before 2000, Brian. So
UK and having to switch over the code, but so needless to say, a lot has changed. 2017 is sort of this rethink. It's an updated guidance from the ABA about some of the considerations when you're going to engage in communication over the internet, whether it's email or whether it's some other form of electronic communication. And I believe we've included Formal Opinion 477 in the materials that we've provided, because I think, especially toward the end, it kind of walks through, 7 or 8 considerations about, what you should do. Do you have a program in place? Are you sufficiently secure? Are you taking into consideration possibility of unauthorized access to your email or to your systems? So that's really the essence of Formal Opinion 477. It makes clear the lawyer may transmit information relating to the representation of a client over the internet, but sort of the change is that the lawyer needs to take reasonable efforts to prevent inadvertent or unauthorized access to the client information. There may be a requirement to take special security precautions, depending on whether, the type of relationship with the client or the nature of the materials. So if I'm, just a real world example, if I'm sending it under the 1999 guidance, there's a reasonable expectation of privacy. Nothing wrong with me sending an account statement to a client via email, as long as that client has authorized email as a acceptable means of communication. Under the 2017 guidance, you need to think twice about what you're communicating, what you're sending over the internet, and perhaps an account statement just with regular unencrypted email, that might not be sufficient security. In fact, it isn't sufficient security, and you need to ensure that you are taking steps and actively demonstrating that you are protecting your client's information. Jerry, I know you must deal, daily with emails, highly sensitive nature with your, the different contracts throughout,
Yeah.
your family.
One thing I would definitely note, and you've got this in your Rule 1.6 considerations, you do really need to think twice about the manner and method of communicating with clients, and even internally, and whether, it's going to be a different experience outside. You're communicating with clients who are oftentimes sophisticated lawyers, the in-house counsel. For in-house counsel, especially, it gets even more dangerous because there are a lot of new regulations and rules, including the GDPR, that now govern for Europe as CCPA in California, where you can face substantial penalties for sending something as simple as someone's name and birthday via plain text email. So if I was going to send something to Brian here, but I accidentally send it to Brian Q. Ellis instead of Brian J. Ellis, I may now be on the hook in the U.S. for violating my client's privacy. But if for our operations in Germany, I may be facing fines from the German Data Protection Office. So you do, as we state, simple routine communications, email's fine. If you're going to send anything that contains confidential or personal information, even an account statement that's got detailed time records, and this is again speaking for lawyers and law firms, detailed time records can cause problems later on if they're found in an unencrypted format.
Yeah, I mean, it's an excellent point, and always consider and discuss with your client the mode of communication, how you're going to be sending your client's information. So Rule 1.6 is, lawyer shall not reveal information relating to the representation of a client unless that client gives informed consent. And one of the things we'll talk about a little bit later is when you send an email, the information you're sending you might be sending more than you think. When we talk about metadata and some of the other potential attachments that might be parts of emails. But in any event, it's important to make reasonable efforts, and this is the impact of the rule, make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information relating to representation of a client. It may be as simple as just using zip the file, create a password, send the file, and then follow up with a separate email with the password. just make reasonable efforts to protect your client's information. Okay, so two opinions here, and I think these were fun cases to kind of go through again. And so Scott, it's from 2007, and the next case will be Stengart from 2010, I think it was decided. And these are, I think, unique cases because they show, there's a little nuance between them. And I think it's a good sort of to keep in mind the differences in some of the factors that the courts discuss. So in any event, email in the workplace, these cases involve the attorney-client privilege as it relates to email communication. So Scott versus Beth Israel, basically what happened was Scott was a doctor. He was a high-ranking doctor, head of a department, was involved in the policy making, and basically was responsible for getting certifications from the staff that they will not use email for personal purposes, that they understand that the email systems and servers are the property of the hospital, et cetera. And in any event, he ends up getting terminated and files a contract claim against the hospital with respect to the nature of his termination. He said that if it was without cause, he was entitled to a larger payout. The hospital claimed it was for cause. In any event, the hospital contacts him and says, hey, we have emails on our system that you basically communications between you and your attorney about the claims that you were intending to file against us on our system. And, we're going to go to the court. We intend to use these. And the court essentially rejected the attorney-client privilege over these emails. I mean, the highly lauded attorney-client privilege, the court said, no, you, Dr. Scott, understood the policy. You understood you didn't have a right to privacy in your business email. And the emails themselves, it's not like the hospital had to go digging. They were on the servers. Here's the emails that you, Dr. Scott, were exchanging with your attorney. And the court, not having this sort of a matter of first impression, it looked to the federal court for actually a bankruptcy decision in matter of Asia Global Crossing. And there were, the four factors that the court looked at to determine whether or not the attorney-client privilege has been waived. So first, whether there's a policy banning personal or other objectionable use of the email system. There was. And in fact, this Dr. Scott was involved in compliance with that policy. The employer monitored the use of the employee's computer email. Yes. Third parties had a right of access to the computer emails. Yes. It was the hospital's property. And the employer advised the employee. Yes. So under this circumstance, using business email for personal purposes, including conversations with an attorney, which would otherwise be privileged, the court said no privilege. And that's, again, New York, 2007, remains good law. I'm sure it's been interpreted, but that's sort of like the groundwork consideration, base level considerations that I think everyone should have. So Stengart, a little different. New Jersey. And a lot of these cases, these are sort of foundation principle cases, but in this case, the difference was, this was a law against discrimination claim filed by a former executive with a rehabilitation agency. She was given a laptop by her employer, and she used the laptop to log into her password-protected Yahoo account, her personal Yahoo account. So she used the employer-provided laptop to access her own private password-protected email to communicate with her attorney about potential law against discrimination claims.
And Brian, can I jump in for 1 second?
Absolutely, yes.
One thing is, with the current pandemic, with all of that's going on, this is a big issue because I'm sure that a lot of us, including me, are working at home on company-provided computers. So don't forget, and especially looking at this, don't forget that ultimately, if you're working at home on a company-provided computer, it's still the company's computer. Now, maybe bring your own device policies may matter, maybe other things may matter, but one of the key things here is going to be that they issued her this computer that she could take with her and use both at the office and wherever she wanted to work. The other issue, as Brian just mentioned, and I'll let him finish, is that is the fact that this was her private personal email account. So this is that but C we all love seeing in when we're reading an opinion.
Right, absolutely, yeah. And this case is, I think, a perfect example of that, because what happens here is now the employer has the laptop, and the employer actually digs into the data, mines and recreates from the hard drive the emails that this former employee was sending to her attorney. And not only did the court say, all right, she used her private email, the attorney-client privilege is preserved, even though it was a company-provided laptop, she had a reasonable expectation of privacy in her own emails, stored on the internet, password protected, Yahoo personal. Not only does the attorney-client privilege stand, but the employer's counsel, this New Jersey Supreme Court, said that the employer's counsel violated RPC 4.4b by violating the rights of third persons and actually recreating these privileged emails, and read them and used them in discovery, the limited discovery that had been exchanged in that case. It was, the court said you can't do that. That is not, you cannot mine, even just because it's and just before I get too far, one of the other big issues here, and one of the things I think is a lesson, is that the policy, the employer's policy, loving care agencies, email policy, electronic records policy, it was all over the place. According to the court, it couldn't determine, even if the policy that the employer was saying, this is the one that applied, court said, well, there's really nothing to support that, and you have all different versions of this policy. It's all over the place. So one of the things, if you are advising a company, make sure your policy is clear, accurate, communicated to your staff, and follow the steps in Asia, and take a look at the formal opinion 477 as well. I think that just really good things to think about. And a lot of times now that we're in this era of COVID and we're working remotely, it's good to refresh yourself on some of those issues. Moving on to metadata, and I'm aware of the time, and I want to, in a few minutes, we'll be giving you the first CLE code. And I also, again, want to make sure that I want to get through some of this so we can talk a little bit more about the etiquette. So I will try to move this along. Metadata, Jerry, this is a thing that comes up quite a lot. I mean, when you're sending an email, or when any document, any file on your computer, there's a lot about that file, information about the file that you don't see, but that can be reviewed and is often communicated to third parties. So, a lot of times you're doing an email review. You've got an Excel spreadsheet. Are there hidden columns? Are there hidden rows? What are the properties? Is there a redlined version? Is it in track changes? Are there comments? Are there author notes? You need to know everything about your file before you produce it, before you send it to a third party. You need to know what information you are disclosing, especially if it relates to your representation of a client.
Right. I see that we do have a question, and we will try to come back to that at the end. So just keep placing your questions in the chat. I saw that there's at least one already. Going back to this, ultimately metadata you can never get rid of it, because even creating a metadata-less file creates metadata about the fact that there's no metadata in the file. So ultimately, as a lawyer, you should not, the key thing is you should accept the file as it is. You should not be using, now, if you find out someone's misrepresented or lied, obviously that should be something that you can bring up. But you should use the tools that you have available to remove metadata. And of course, Brian, I think this may be a later slide, but one thing to keep in mind is, if you do generate an email, what we see is when you send an email or you send the Word file, what you see is just what they want you to see. What's underneath that is code about, is text about how it went through the system, what servers it passed through, the date, the time, for a Word file. That can be printing data. That can be all that. personally, what I found, and what even in our GC discussions that we have that we have groups for in-house counsel, a lot of attorneys are going back to redact in PDF, print it out, scan it back in, and then send it to the other side, because ultimately that may be the only way to ensure that you're not sending them something inadvertently. And because a lot of one of the big problems, of course, is always, did I send a Word document and all I did was highlight with black marker inside Word? Because Control C, Control V, and you've unredacted that document. But you have to approach it cautiously and be aware that you're never going to get rid of everything, but at the same time, you need to make sure that what you're sending is clean and usable. And the other corollary to that, of course, is in discovery, you're supposed to produce a native format as much as possible. I am not a litigator, so Brian, you can correct me on that. But ultimately, you need to be aware that you may be in a discovery situation producing metadata, but it's your opposition's obligation to not use that to not use additional tools to discover whether there's something secret and hidden in the metadata. They're supposed to be able to rely that you produced it in the most applicable format possible.
Yeah, I mean, certainly the court or regulator or whoever will have rules on electronically stored information and the proper means to produce it. And it's just to be aware for our purposes today. I think it's just be aware that there's additional information. One of the things I think Jerry and I talked about yesterday was, any file on your desktop, if you right click on it and go to properties, you're going to see the metadata. You're going to see at least a portion of the metadata and what is, what's available there. These ethics opinions are, their guidance, their authority, basically saying you cannot mine information to discover confidential information. Just again, a couple of things. Just know what you're sending, and we'll talk about BCC and reply all a little bit later. But I'm going to move forward now a couple slides. Rule 1.1 is really just competence. I mean, this is the bedrock. Every lawyer, every time wake up in the morning before you go to sleep at night, should, rule 1.1, stay up to date with what you need to know to be an effective attorney. And that includes technology, relevant technology. And now more than ever, I don't want to get into the cybersecurity issues or data privacy issues, but we're remote in a lot of ways that we haven't been before, and we're relying on technology in ways we haven't before. And I just think it's super important to stay up to date, to know what questions to ask. You don't have to have all the answers, but you need to at least be able to think about, all right, what are the questions that I need to ask about my own systems, my own practice, and what do I need? What are the reasonable efforts that I can take to protect myself and to protect my clients? Just really quick, we have a couple attorneys here who didn't think it through. The first, this Minnesota case, these are just a couple examples of attorneys that maybe got on the wrong side of their respective ethics regulators with respect to their use of email. So the first one, an attorney who lives and practices and is barred in licensed to practice in Colorado, was sending emails into Minnesota to negotiate a small collections matter on behalf of his in-laws. He stated in the email that he represents his in-laws. Essentially sending email into a jurisdiction and practicing law in that jurisdiction could be unauthorized practice of law. And this Colorado attorney again found himself on the wrong side. If anybody has questions or wants, I'm happy to send along the background information here. I just didn't want to embarrass any of the attorneys' names. I feel like it's really the top line sort of story rule that comes from these. Just kind of what not to do. A couple other New Jersey attorneys, and I have some examples of some of the language that would put into an email. The first attorney was being investigated for disciplinary charges and decided he would put into email in all caps in bold, quote, "It's an effing atrocity that an honest law-abiding attorney should have to go through this 4-letter word. Tell the director of attorney's ethics I said to go 4-letter word himself. You can quote me in your report. No offense against you. I know you're a decent, honest guy. Regards." So that email came back to bite him. Another one here, this 2014 matter. These are emails sent from an attorney to his client. "Don't feel you have to email me daily and let me know just how smart you are. That's one. This will acknowledge receipt of your numerous emails, faxes, and letters in response thereto, blah, 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 blah. Did you get beat up in school a lot because you whine like a little girl?" I mean, these are, don't do this. There's no need to. I mean, that's really like the bottom line. Before you click send, and I think we've all been, we've all sent emails that we may have thought twice about later, and it's a good experience, but you are creating a permanent record. And we'll talk about this a little bit later. And again, attorney's ethics, you have to act in the highest, you should, don't let yourself be one of these folks. Jerry, I was talking about folks not to be like. I'll let you.
Oh, so this is personal for me. I actually just handled a mediation and with this gentleman judge. This just happened. It came out on the news last, I guess, 2 weeks ago. There's a judge who, and by the way, this goes linked into the previous slide. Sorry. If you have to think twice, if at any point you think that something could be bad, whether professionally or personally, just stop, walk away, and read it again later. But in this instance, a retired judge in Chicago sent out an email talking about how Black people are inherently inferior, which immediately got shared among all the other attorneys and judges and everyone in Chicago and around the world, and was then let go of JAMS, which, by the way, had just released a statement about how wonderful they were at diversity and inclusion. But they then had to release a second statement about how they now have to go through a much more in-depth vetting process. The rule here is, and I know some of my team are actually listening in right now. One thing to always keep in mind is I personally set up a 1-minute delay on any email I send in case I got excited, so that I can go back and stop it from going out. But I think we'll go into this in a moment. It may be the next slide, Brian, about how to draft an email. I remember the slide is there. So, but just take a second, professionally and personally, before you send something. Especially if you know that what you're saying could be racist, insensitive, discriminatory. All of that is very important. Unfortunately, I can't go back and argue that the mediation was wrong because I then settled the case. But if this had happened now, I would have gone back and asked for a new mediator and a new session, because obviously now we would be able to argue that there's bias against someone somewhere.
Yeah, for sure. Excellent points. Let me give you the first CLE code. The first CLE code, and I'll put this in the comments as well. Reply all. REPLYALL. Reply all. Okay, and we're making good time. So we're going to move on to section 2, part 2, email etiquette, best practices, just some, this is, I think you'll get the point. So we'll start with reply all. There's very rare circumstances that would require an actual reply all. And I think before you decide that your message is the one, and again, we've all been on both sides of these emails, but just to kind of think about, the do unto others inboxes as you would have them do unto yours. If there's certain messages are worthy of being blasted to everyone. Most aren't. And I just think that with internal firm culture, communicating with groups of attorneys, whether it's with the bar association, communicating with clients, colleagues, even friends, people don't want to see reply all the time. So there's a time and a place. And I think often if maybe you're going to be carpooling, or you have a small group of people who are working on a project, and say you're doing an email review, for example, and one reviewer is seeing some interesting things that they want to share with the review team. Great use of reply all. Keep everybody in the loop. Everybody's going to want to know what you're seeing because they're all focused on the same task. So just a couple words there, Jerry. I don't know if you want to offer any comments on the reply all.
No, I think that's pretty much, well, I do, but I'm trying to be mindful of time as well. I do think it's really important. One thing, and we'll get into this in a few minutes, is are there other ways for you to have a discussion that doesn't involve reply all? Whether it's in a chat session, obviously these all have their own issues from a litigation standpoint, discovery, from a management standpoint. How do you control what people are saying in what appears to be a more private setting? But beyond that, there are technological ways to avoid using reply all, including the reply to feature in many email programs, whether you're in Outlook or Gmail or another system. But also keep in mind that Brian, we may want to just go to the next slide for this one. Keep in mind that, ultimately, when you open up that reply all, you're also opening up CCs and BCCs, because ultimately, and again, Brian, feel free to tell me when you want to start going again. But reply all ultimately sends it back to everybody. We've all been on the end of that 7,000 message undying email chain of people replying all. It happens in even at tech companies. We find it happening when someone does a great deal. All of a sudden, I get 700 emails from sales leads, from other leads, and I sent one good job to the person who did the deal, but everybody replies all instead of just sending that. And ultimately, what is everyone doing with that email? They're clicking delete, or they're not even reading. If you need someone to see something, put them in the to line and send it to them directly. CC, as it says on this slide, carbon copy. Everybody sees it, but I will assure you that, and this is a sad truth of email, if you're not in the to line, people will gloss over that email. It's very hard, and Outlook and Gmail both support this now, where you can call out someone in an email with an @ sign, like it's Twitter, Facebook, Instagram. Going on the BCC, as it says, BCC is really your observation room. You need to see this, but I'm not expecting you to take action. People still don't get that. People reply to BCC, they reply all to BCC all the time. So when do you use BCC? I would say I use it to send things to myself for my own records. I will once in a while BCC in my CEO and follow it up with an email that says, don't respond to this, or a phone call. Ultimately, go ahead, Brian.
I would just going to BCC somebody. I try to give them a heads up. You're gonna see an email coming. This is the response to whoever. Just wanted you to know. BCCs, again, if there's a reason for somebody to know why it's in their inbox, just tell them. Just, hey, I'm going to send you this message, or forward after you've sent it to someone, then forward it to the person and direct, hey, this message got sent over to someone else. Again, sort of along the same lines, the forwarding, when you're adding a new recipient, so usually, you're having an email conversation, there's back and forth among a group of people, and then eventually somebody else gets added. that new person is now privy to the entire chain, the entire conversation. And, it doesn't necessarily mean somebody had bad intentions or whatever, but not every message is meant for all eyes. And if you're going to invite somebody new without at least acknowledging or advising the current group members, you might be setting someone up for embarrassment in one way or another. But in any event, there are times that it's necessary, and oftentimes the messages are benign. But again, it just to alert the rest of the group that you're adding somebody. Sometimes right up in the first line of the text could be plus Rebecca. We're adding Rebecca to this conversation.
And again, I think there is really, we're talking about email and ethics. This is just simple consideration. If you're trying to be a good attorney, if you're trying to be a good practitioner, if you're trying to be a good partner in your business or wherever you're trying to work, draw that attention, because ultimately someone will notice. Now, again, this goes back to the same thing. If you are forwarding and if you're doing this and you need someone to know what's going on, this goes back to that question of BCC versus forward. In this case, I may be asking Rebecca to comment in on something that needs her attention. Rebecca, did you get this file done? Did you send this to the client? Did you worst case scenario, did anybody remember to set up coffee in the conference room? Probably the most important thing on any day is coffee. But keeping that in mind and just getting that in also alerts that there's someone new in the conversation. If you want to think about it in terms of a phone call, if you dial someone in and they're just listening in, yeah, it's probably okay, but it's not really nice of you to do. And of course, in some states, you may actually violate the law by not disclosing that you brought someone else on, or you may be recording the conversation. Just try to be forward if you're doing that. Be forward with your forwards, I guess, is a good way to put it.
I don't like BCC. I'm not a fan of that. When I do forward an email, I do try to think. Again, nobody's perfect, and I'm sure some of my colleagues will have thoughts on this. But I try to think about, if I'm going to add somebody new, let me just make sure that everybody's on the same page.
Especially all the emoji didn't show up. I'm quite disappointed, Brian.
We gave it a shot. I think it's with the viewer. I think in the materials that were circulated, the actual emoji came through, and they were good. It was a good selection of emoji.
Thank you. That's really what I've added to this entire CLE is the emoji.
But no, I mean, the point is, I mean, it's actually a good lesson. Don't use emoji. Just don't use emoji. But
originally this had funny emoji on it, other than the mask emoji. But look, if email is plain text. We're getting it. It's hard to understand what you're sending. Maybe you're making a joke. Maybe you're trying to be funny. Text is very difficult, especially in an email where you're not providing commentary on your personality, on anything else that you are talking. It's not like you're writing a book. Harry walked into the room suddenly flushed with anticipation. In this case, you're sending a note. Brian, I got the message, but I don't understand it. What do I need to do? ? You attempted to put it in. Know who you're talking to. Don't send an email to, that's going to be don't send an email around that may end up in someone else's hands that has a smiley face or poop emoji or whatever you want to call. That may be the first time I've ever said poop emoji in a CLE.
Could have been the code.
The one that's missing was the zipped lips. Just putting a lip zipper emoji is not going to tell someone this email is confidential. Explain what you need, and if you can, in many cases now, you can use server-side rules or features that are available. You might need to talk to your corporate IT team, your legal IT team to see if these are available, but you can restrict forwarding. You can restrict printing. You can either set emails to expire after a certain time. I'm not commenting today on discovery obligations, but ultimately, if you can communicate and explain why, And potentially, if you're telling someone this should not be forwarded, if you have a setting that turns off forwarding, at least you've eliminated the simplest method of sending it to somebody else. They still may be able to take a screenshot. They still may be able to do other things, but ultimately the goal here is to maintain some level of formality. Yes, again, I know my team is listening in. I use emoji all the time, but it's usually great job, smiley face, or oh gosh, I'm so sorry to hear about so and so, sad face. I would never send an email to Brian outside counsel or anyone that's like, hey, really great work, smiley face, but I think these sections are terrible, poop emoji.
I mean, excellent points, and for sure. And there's some level of, again, it's the title of the slide is formality considerations. When you know somebody a long time, if you have a fairly friendly rapport with somebody, again, it's just the considerations. Know that not everybody is going to be receiving your emoji email the same way. You want to think about the effect on the audience. Jerry, I think a lot of these next few slides deal with formatting and presentation. Maybe we want to just sort of go through them quickly.
Yeah.
Just sort of hit the high points. I mean, you want to use the main point from the last slide, and I think is use language to communicate. Don't use flowery fonts or HTML backgrounds, or try to get your point across in a user-friendly way.
Yeah. And the key thing here is if I see all caps, if anybody sees all caps, they assume you're shouting or you're trying to draw attention to it. It's incredibly difficult to read something in all caps. And even, look, I deal with a lot of contracts. You look at them, people love putting limitations of liability and disclaimer of warranties in all caps. It makes it harder to read. If there's something that you have to call out, use bold, use italic, or use caps sparingly.
Yeah, agreed. You'll see in these slides too, there's a lot of emphasis on picking up the phone. I think we talked about these. Picking up the phone is important. And I think it should always be a thought if you are going to send an email. So a lot of times we see these red exclamation points. So, the idea is you want to communicate that this is an urgent message, but everything is important. If it wasn't important, you wouldn't be sending the email in the first place. So there's, you want to think about, why are you forcing the reader or the recipient to respond immediately? Is it necessary? And again, if it is necessary, if you need an immediate response, pick up the telephone. The red exclamation point itself, I think, is a little overused. You can add to the subject line notes like, this is important, please read, matter of life and death, however you want to, call it out, I think is a I'm hitting the wrong buttons now.
I think we lost you for a moment, Brian.
Here I am, I'm back. Okay. But in any event, it's there is if it's important, reach out, have the personal conversation, and pick up the telephone. Jerry, I think these are the slides you're talking about. I'm going to let you go with shorter is better.
This is all I talk about.
Yeah.
One thing I also want to mention about Brian, the last slide we talked about, the importance, is there's a lot of people who schedule time for reading emails. So I don't do this as much, but there are people who go and say, I will not read your email until 5 p.m. If this is important, you must call me. And it's just because they have other things to do, and they've realized that every email is important, or everybody thinks every email is important. But if you need to reach them for something urgent, pick up the phone. So look, now we're into, the slides are actually starting to reflect what they say. This is always a difficult problem for lawyers, especially, because you want to get to the point, you want to be concise, you want to explain what they need to know. But at the same time, we're also trained sometimes as attorneys to do good news, bad news, good news and put the bad news in the middle. So, it's hard, and we have to be mindful that we we do want to sandwich bad news and good news, and everybody wants to do that. But if you've really got something that you need someone to take action on, don't bury it in the email. Explain why. But this leads to the next slide, which I think is shorter is almost always better. If you send, and again, lawyers, we're trained to write. We're trained to write long things. If you send a very long email, people don't read them. I try to teach people a lot of the time, your email should be 5 sentences or less. If you've written more than that, you may have to, you've clearly put too much. You may want to write a memo. You may want to explain why. You may have to pick up the phone, or you may have to do a presentation. If you're sending something long, send it as an attachment. I did practice in Japan for a while. They don't have, a lot of other countries don't have attorney-client privilege the way we think of it. So an email between Brian and I as outside counsel, inside counsel, may not actually be privileged, but they have a specific way of protecting confidentiality. So attorneys in Japan, for example, send their communications and their drafts with an encryption and a password protection to protect that right of confidentiality. We don't think of it as much because we generally rely on privilege, but ultimately, if you're going to send something long, attach it, password protect it if you can. Look, are we always going to remember to do it? Of course not, but it helps to start thinking about that. And then as far as emails themselves, shorter is almost always better to make sure someone actually reads it. I send a lot of short emails, bullet points with key items. If I need someone to take action, highlight, urgent, action item, at message, whatever works to get their attention to take care of those items, but so that they actually read it.
Yeah, I think that sort of the
go ahead.
Privilege, the nuance in Japan, I think that's really, it's sort of reflective of the Stengart decision and the cases that we looked at. I mean, and even the formal opinion 477, it's what reasonable efforts are you taking to protect this message? It almost puts the onus on the attorney and on the client to actually put some effort into demonstrating that it's actually privileged and confidential. And yeah, shorter being better. I always figure that the person I'm sending the email to is going to be reading it on their phone. I try not to use long paragraphs. I try to put right at the top, here's what you need to know. And if you want to keep reading, here's some additional stuff. Encryption, this is another sort of area that talking about reasonable efforts to protect the information. Yeah. Plenty of ways to do it, plenty of ways to protect emails, secure emails, and other ways, other modes of communicating with clients that might offer a greater level of protection. Again, I'm mindful of the time, so I'm going to go through a slide here. Proofread. I think proofreading's well worth the time. I think the key takeaway is, you want to build confidence. You want the people you're communicating with to have confidence in you and in your preparation, your attention to detail. It takes a long time to build, and one typo, and everybody is going to have a typo here or there, but just really make a real effort to try to minimize them. Following up and knowing your audience and understanding the benefits of a telephone. Those are the last few slides here, and I think it's worth kind of thinking through the email process and what you're trying to accomplish. You want to send a quick message to somebody. You want to communicate. You want to ask a question. You want to put out a request for information. You want to provide information. You're sending the message for a reason. If you're not getting a response right away, if you're expecting a response, this is sort of a lot of times you need to hear back because you're going away, or you've got a vacation, or you've got something to do. Your schedule is your schedule. Don't think that your email recipient is going to be working on your schedule. We talked about communicating urgency. We talked about ways to get quick answers. Go ahead.
I was going to say the closest thing I compare this to is you're looking over a response. If you're not getting the response, you have to recognize that person's also busy. If they haven't followed up, do that. If they still haven't followed up, pick up the phone. true story, and this is terrible, and I know we're running on time, but my uncle once had, and this is a true story, his attorney passed away in the middle of a proceeding, and not at the proceeding, but while doing something, and he didn't follow up. So a month and a half later, he finds out only because opposing counsel actually called him to say, who's your new attorney? So, at least follow up. Try to make that phone call. Try to find out if there's a reason why they're not responding. Don't push it too hard, of course, but, at some point, you're going to have to pick up the phone and find the next question.
I think that when you're talking about emails and what you're putting in writing, you obviously want to think about the recipient. Obviously it's part of your audience, but one thing I learned early on as an attorney at Bressler, I remember attending a CLE where Mark Talmadge was explaining what the E in email stands for, exhibit and eternal. I mean, your audience, when you're drafting an email, especially if it's a professional business email, but really any email, your audience is unknown. I mean, you have to consider every word as if it's going to be read in open court, as if it's on the front page of a nationally distributed newspaper, and as if your reputation depended on it. I mean, far too often we see people have, rightly or wrongly, their reputation's completely shattered based on information that they included in emails. So just use the precaution. I do see a couple comments. Obviously I see Kay mentioning some managers want all details rather than just the top line bullet points. Yeah, get to know the folks you're working with. Obviously, if you're reporting to supervising attorneys, if you're delegating, if you're a young associate or a summer associate, if you're in-house counsel, know who you're working with and how they prefer to have information shared with them.
Yeah, I think that's the key, Kay. Yeah, some managers do want different styles. What you have to keep in mind, I've tried to come up with a method that solves both a short message with an attached memo that solves most of these problems, but you're always going to do it with the way someone wants to work with you. So of course, these are general ideas. They're not absolute 100% ideas. But I think a lot of this comes down to KISS. Keep it simple, and I won't say the last part of the phrase.
The best part of email is how quick and direct it is and how it's organized. I mean, I look at my email. If I'm sending an internal email or email to a client, I consider it a memo. You have your to, you have your from, subject. You can get into it. It's really an opportunity to really convey information, easy to organize, easy to recall method. It's also sort of taking over as more formal mail. I mean, I think that a lot of communications are now sent, please see the attached correspondence.
Well, even worse. Yesterday, I think the State Bar of Texas, the Supreme Court of Texas, authorized service of process via social media.
Well, there you go. I mean, it's a changing world, and that's part of it. And again, just to harken back to that opinion 477, definitely worth a read. A lot of good take-home messages about what is reasonable, what you should think about, what you might need to know if you are starting off your own law practice. A lot of folks looking to get involved. What are the rules? What are the ethics rules, and how do they apply to methods of communication? Finally, the last slide here, picking up the phone. Just such an easy way to communicate. When I started, the phone was referred to as the most important tool you have as an attorney. It's a way to establish a connection, to discuss matters in real time, and to really understand the needs of the person or the people that you're talking to. So, if you're going to send an email, fine, but consider picking up the phone before you send the email. And especially if you need an immediate response, if it's something that if you're going to send an email, fine, show up in their inbox, let them know it's immediate. a phone call, even if it's a voicemail, it's a level of personal connection that, especially today, and I'll say it, the era of COVID, it's very useful to hear another voice on the other end, and to know that you're working on something together.
It is. Can we go back? I think Peter had a question about encryption at the very beginning.
Yes.
I know we'll get you the code. I know all of you who are waiting for the code. We'll get that in just a second. Peter's question was, when should we use encryption? That could identify someone or reveal a merger acquisition might be in play. What is sensitive enough that you would turn to encryption? I personally, have got to the point where I'm starting to put encryption on almost everything that I can. I think just as a personal safety precaution, and also, we'll have conversations via encrypted channels. I can't tell you. You have to use your own judgment, but I would sit down and say, what am I worried about someone else seeing, and what do I want that person? How do I want that person to receive this information?
If I could jump in real quick too,
Yeah.
and so that absolutely important, but also have the conversation with your client, because again, you need informed consent with respect to any information that you're sharing that relates to representation. So
Right.
If you're going to use encryption, your client may require encryption, or should at least be consulted with respect to the method of transmission. Certainly, it doesn't hurt to encrypt or use secure email across the board. It's a little clunky. It slows things down, but I would expect that anything that's confidential, proprietary, personally identifying information, confidential supervisory information, anything that may have some gravitas. Personally, if I'm emailing a client, the email itself is going to be text. If it's something of import, it'll be an attachment, and it'll likely be a secure attachment.
Yeah, I was going to say, I use encrypted messaging systems just because we can't be sure. Obviously, some of you are maybe data protection attorneys, privacy attorneys. We can't, in the US especially, we can't be sure what people can access. We don't have the data protection regime that exists in Europe at the moment. So if there is something that you're concerned about or that you're worried about, encrypt it and make sure you're communicating with the right person. I'm happy to take more questions on this later, but I think everybody got my email in the early email from Rebecca. So feel free to reach out if you have questions on that, or you want to talk to me. I love talking because we're all locked inside still.
And if anybody has questions or follow up, don't hesitate to reach out. I mean,
Yeah.
certainly, this is an ongoing discussion, and it's an evolving landscape. As attorneys, we have ethical considerations that should play a role every time we click send.
Absolutely.
The second CLE code is BCC. So you've got reply all and BCC. Again, I want to thank Jerry. Jerry, it's great to work with you.
Well, we spent what, 16 years of our lives. We've since law school.
Yeah, and it's wonderful that we're in the same area. We share a building in the city. I'm looking forward to seeing you again soon.
Hopefully we'll all be let back in soon.
Let's hope so. And to everyone who attended, thank you very much for taking the time. Hope you found this at least a little bit entertaining, hopefully useful, hopefully spurred some thoughts about how you can better protect yourself when communicating electronically.
Absolutely. Thank you all for attending.
All right, signing off now. Take care. Bye-bye.